let's talk about pinging a cell phone that was stolen during a robbery in California. Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing a roadside chat. Just real quick though, I do have some exciting news for my followers. We are moving studios, and so this is kind of blank. I'm actually, I have a few guns just to, for background. But our new studio is going to be off the hook. So keep that in mind and look for that in the beginning of 2025, our new studio. All right. So this officer is in California. He said, all right, we had an armed robbery last week. 2 suspects armed with a large capacity handgun and a rifle. They don't mess around. Robbed a taco truck. These guys meant business. Maybe they expected some pushback. During the robbery, the suspects took 3 cell phones from the workers. An emergency ping was requested and activated. There was some discussion afterwards of whether this ping was justified under 1546. I'll talk about that. My understanding of the law is that we were pinging the victim's phone and not the suspect's phone. Okay. The emergency and/or agency was to assist in apprehending armed robbery suspects, violent suspects, absolutely, prevent any further robberies, seize evidence to prevent the destruction of evidence. Was our agency good to go to ping it? Absolutely. Absolutely. So let's talk about the Electronic Communications Privacy Act. That's 1546. And it talks about different exceptions to for location information. And it says in subsection C, a government entity may access electronic device information by means of physical interaction, right? Or electronic communication, which would be with the device only as follows: pursuant to a warrant, wiretap order, tracking device search warrant, or with the specific consent of the owner of the device, only when the device has been reported as lost or stolen. Well, you have this, right? I'm sure that you either have express or implied consent from this victim to find their cell phone. I mean, undoubtedly, they're going to give you consent. They've given consent, either express or implied. I would like express consent. Or subsection 6 says, if the government entity in good faith believes that an emergency involving danger or death or serious physical injury to any person requires access to the electronic device information. So either way, you're going to find. There is actually a third thing that's not talked about here, but what about a lack of standing, right? So how does a person who steals a phone have a legitimate privacy interest in that phone's location? That would just be a exclusionary rule issue, right? Even if somehow this was not authorized by law, which it is, right? But let's say that the court did not find any agency, which they would in this case, and they did not find any consent, which they probably would in this case. Let's just say they didn't find no agency or consent. But how would, at least under the Fourth Amendment, under a fruit of poisonous tree, how would they contest that? Like in California complies with the Fourth Amendment standard for the exclusionary rule by constitutional amendment. So they have to comply with standard Fourth Amendment rules, and I just don't know how, at the end of the day, that they can complain about this. There's clear case law that a thief does not have a privacy interest in the location of a stolen cell phone. So, but regardless, it's nice to have statutory authority directly on point. That's what it is. I'll put this law in the description below. If you have any questions about this or anything else, reach out to us at bluetogold.com. If you like what we're doing here, you know what to do. Like, subscribe, share with your friends. It really helps us out. Until next time, my friends, you stay safe.